There's no need for immediate panic. Nobody just outlawed BDSM, and the cops aren't going to come knocking on your door. That said, there's been a major court decision that has the potential for a huge impact on how BDSM is viewed, and it's something you will definitely want to know about. We'll tell you in this special episode of VMAP.
So, recently, you may have heard through social media about a U.S. District Court ruling which asserted that there is no constitutional right to consensual BDSM sex. In this VMAP special report, we're going to cover what the GMU case was, provide some background on how constitutional law works, and the other cases referred to in the decision. Then we'll look closely at that decision and what it means for you.
The court case that has the BDSM world talking is John Doe versus the rector and visitors of George Mason University. So, what was this case about, and what did the judge actually decide?
In fact, you don't need to know the details of the case to understand the ruling, but we think it can be helpful to get a clear picture of what was and wasn't being decided, and help unconfuse your friends as to what was and wasn't on the line.
Back in August 2012, one John Doe, not his real name, began a relationship with one Jane Roe, not her real name, at George Mason University, a school, incidentally, which James attended back in the 1980s, which brings it fairly close to home for us.
Like a lot of BDSM relationships where there's little guidance or experience, things went poorly. If you believe the campus reports, Doe had some attitude problems, and was on the radar of the campus assessment and intervention team, which investigates students who might harm others. We don't know the truth of the matter, but our business here isn't to defend Doe, just to explain what went on and how the ruling worked.
Doe and Roe broke up in early 2014, and some months later she got in contact with the university, so that Doe was brought up on charges in September 2014 before a 3-member panel of the University Sexual Misconduct Board, which consists of GMU faculty members and staff.
In Doe's initial hearing, he was only told the case related to one event, October 27, 2013, in which Roe did not claim he ignored a safe word.
After discussing BDSM with Doe and understanding about safe words, the initial panel didn't believe he'd actually broken the rules and found him not responsible for each of the 4 charges.
Brent Erickson, an assistant dean of students and director of the Office of Student Conduct, who had been in close contact with Roe, did not like that outcome. Through a series of irregular administrative procedures, he essentially overrode the panel and expelled Doe.
Doe then sued the university for wrongfully expelling him.
The bulk of the lawsuit revolved around the fact that Doe wasn't told he was to be on trial for the entirety of his relationship, and wasn't told about some of the evidence that was used to decide his case. Because GMU is a state school, Doe was entitled to constitutional due process.
The court ruled in favor of John Doe and said GMU had railroaded the legal process. Again, we're not here to defend Doe. Clearly he left Roe feeling burned and upset, and from the few quotes we get from him, Doe does not come across as a responsible dominant. What brings us here is a side issue that came out of the case.
In his initial list of several flaws in the process, Doe asserted that Erickson disregarded the BDSM context of the relationship and how it affected matters like consent and related issues, and treated a BDSM relationship as per se sexual misconduct, arguing this constituted a violation of his right to sexual liberty as protected under Lawrence v. Texas, which held that a state could not criminalize intimate sexual contact between consenting adults.
Now, this should have died then and there, because this part of Doe's argument was dismissed on essentially technical grounds. What's remarkable is that even though it was already moot to the case, Judge Ellis decided to go out of his way to address it, in his opinion, saying he wanted to present an additional rationale as to why the Due Process Clause of the 14th Amendment does not prohibit the regulation of BDSM conduct.
That is, to quote Vice President Joe Biden, a big fucking deal.
This is a big fucking deal.
First, a little constitutional theory. Now, maybe you're thinking, as Judge Ellis did, that BDSM shouldn't be protected as a basic liberty. And to be clear, we're not expecting courts to enumerate tying and flogging as basic rights. Nevertheless, there is an emerging consensus in this country that intimate sexual behavior between consenting adults is a basic protected liberty, and this decision severely eroded that consensus in a way that's specifically harmful to the BDSM community.
To understand what's at stake, we need to understand a little about constitutional law.
In the US, lawmakers can't just make any law they want. Basic or constitutional liberties trump laws, and laws or processes which go against them are unconstitutional.
Unfortunately, figuring out what constitutes basic liberties has always been difficult. In general, conservative judges see basic liberties as only those which are strongly grounded in history and tradition, like owning property, while progressive judges tend to be forward-looking, understanding new rights like a woman's right to control her body, based on our contemporary needs and understandings and in pace with the growth of human rights around the world.
Most basic liberties come from one of two constitutional clauses, and that will come up in the decision, so we're going to review them.
The Due Process Clause, rooted in the 14th and echoing the 5th Amendment, says you cannot be deprived of life, liberty, or property without due process of law. What that means is that you can be deprived of liberty or property as punishment for a crime, but not without a fair trial, and no law can be made that contravenes that requirement.
The Equal Protection Clause of the 14th Amendment says that everyone shall have the equal protection of laws. This means that lawmakers can't make one set of laws for, say, white male Americans and another set of laws for African Americans or women.
The final idea you may need to understand is precedent. Judges don't just interpret the law fresh every time a case comes up. They find a similar case and apply previous decisions called precedents. For the geeks in our audience, saying that a judicial case sets precedent is like saying that it has become official canon.
Now we're going to look at 3 cases Judge Ellis referred to in his decision.
Washington versus Glucksberg. At first, this case doesn't have anything to do with BDSM at all. Dr. Harold Glucksberg challenged Washington's law against assisted suicide, saying the right to die was a liberty protected by the 14th Amendment.
Then Chief Justice Rehnquist disagreed, making a strong point that liberties not deeply rooted in the nation's history do not qualify for protection. By this argument, if something hasn't traditionally been a liberty, it doesn't become one just because times and standards change.
Glucksberg was a huge victory for conservatives and damned forward-looking interpretations of the Due Process Clause for a quarter century. There's a lot wrong with it, including the fact that many due process decisions before Glucksberg, such as Griswold and Eisenstadt involving contraception, as well as the famous Roe v. Wade, were forward-looking.
Nobody wants to see the right to Starbucks made into a human right. That said, times change, and science and society change our perceptions of things like privacy, homosexuality, polyamory, and the consensual practice of sadism or masochism, and guide us toward an understanding of personal sexuality and intimacy as a universal right.
Progressive jurists such as New York University School of Law professor Kenji Yoshino hope Glucksberg is steadily being eroded into a bare remnant of abandoned doctrine, but right now it is the barrier in precedent to the progressive interpretation of new universal rights.
Lawrence v. Texas. Lawrence versus Texas is the case that made sodomy legal. In September 1998, a jealous partner called the police on John Lawrence, a 55-year-old gay medical technologist, and his partner, claiming there was a black male going crazy with a gun. The police didn't find any gun, but 2 officers said they saw Lawrence and his partner, Tyrone Garner, engaged in oral sex. Detective Joseph Quinn didn't like Lawrence being verbally assertive, and didn't like seeing a white and black man together, and didn't much like homosexuals. He charged the 2 under a deviant sex statute, and they spent a day in jail.
Gay rights organizations such as Lambda Legal had been waiting for a clear-cut case like Lawrence, and despite a fine of only $125 in the case, they drove it to the Supreme Court by 2003. The court ruled that the case does involve two adults who, with full and mutual consent from each other, engaged in sexual practices common to a homosexual lifestyle. The petitioners are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime.
Lawrence knocked down anti-sodomy laws for gay and heterosexual couples across the land and paved the way for legalization of gay marriage. It also took a couple of shots at broadening Glucksburg.
For our purposes, the important thing about Lawrence is that it also made something of history, mostly encountering a homophobic statement in a previous ruling where Chief Justice Berger had said, "Decisions of individuals relating to homosexual conduct have been subject to state intervention throughout the history of Western civilization. Condemnation of those practices is firmly rooted in Judeo-Christian moral and ethical standards." The majority in Lawrence said that other cases showed an emerging awareness that liberty gives substantial protection to adult persons in deciding how to conduct their private lives in matters pertaining to sex. History and tradition are the starting point, but not in all cases the ending point, of the substantive due process inquiry.
Finally, but importantly, the court in Lawrence said that non-enforcement was a factor in considering if a prohibition was tradition.
Most of you probably recognize Obergefell, the gay marriage decision, since it just happened. Obergefell was actually a culmination of several carefully curated cases. The key thing about Obergefell is that it was a major expansion of the understanding of basic liberties under both the due process and equality clauses. In referencing Lawrence, the majority in Obergefell talked about the two liberty claims as being entwined, opening an avenue for more progressive interpretations.
It won't surprise you to know that conservative Justice Alito invoked Glucksburg in his dissent of Obergefell.
It's rather strange to have a major legal precedent against your sexual practices set by a case in which the relevant items were dismissed. Nobody can know for sure why a judge chooses to address a certain point in his decision, but we think it's because the rather conservative Ellis was very concerned that in siding with Doe on the procedural and free speech issues in the case, it was clear that he wasn't supporting BDSM.
Early in his decision, Ellis makes it clear that he sides with the late Justice Scalia in a conservative view on liberties that are not expressly written into the Constitution. He agrees new liberties may exist, but feels that the fact that the Ninth Amendment doesn't deny them doesn't obligate judges to uphold them either, basically letting the courts off the hook for defending any basic liberties that aren't written in ink in the Constitution. He's willing to make an exception when a group has been systematically denied a freedom, but that's as far as he wants to go.
Ellis first breaks out two traditions of defining basic liberties.
First, he talks about Glucksburg outlining a two-part test that a basic liberty must be rooted in history.
Ellis rather sarcastically comments, "There is no basis to conclude that tying up a willing submissive sex partner and subjecting him or her to whipping, choking, or other forms of domination is deeply rooted in the nation's history and traditions or implicit in the concept of ordered liberty."
Because he clearly doesn't pay attention to modern movies. Judge Ellis then takes on the precedent of Obergefell and Lawrence, which he correctly says balances private interests against social needs by reference to, but not bound by, historical practice.
Ellis reasons that in linking due process and equal protection, Obergefell suggests that the decision to recognize a basic liberty turns on whether the liberty interest at issue has historically been denied on the basis of an impermissible animus, or alternatively on a legitimate basis aimed at protecting a vulnerable group.
Effectively, he argues that Obergefell granted liberties to homosexuals because their denial was based on condemnation, but did not grant liberties in Glucksburg because the state's interest was rooted in protecting those who might be vulnerable from committing suicide.
Everyone understands that the state can deny a fundamental liberty when there is a compelling interest. This is why you can't yell fire in a crowded theater, despite freedom of speech. What Ellis says is that the courts have no business or authority trying to protect rights that aren't written down by name in the Constitution, unless there's some historic wrong to right, such as injustices towards African Americans or homosexuals.
Ellis ties the whole package together by pointing out that Lawrence still references history, and therefore makes the tests in Glucksburg relevant, trying to ignore the progressive interpretations of Obergefell as an exception and tie the law back to Glucksberg. He then goes on to say that there is an absence of impermissible animus toward BDSM, a legal term which roughly means fear, denial of rights, and unfair prejudice.
He concludes, sexual activity that involves binding and gagging or the use of physical force such as spanking or choking poses certain inherent risks to personal safety not present in more traditional types of sexual activity. Thus, as in Cruzan and Glucksberg, a legislative restriction on BDSM activity is justifiable by reference to the state's interest in the protection of vulnerable persons, i.e. sexual partners placed in situations with an elevated risk of physical harm.
Despite the severity of the ruling, it doesn't actually change anything, which in many ways makes it so much more frustrating. It's a blanket ruling setting precedent that BDSM isn't constitutionally protected, but it upheld no law or even a campus policy. It was about a largely theoretical and perceived administrative bias. It was a totally unnecessary ruling and vastly overbroad.
By overly broad, we mean that presumably Ellis would also rule in favor of a law that restricted men over 40 from having sex due to the increased risk of heart attack.
The fact that nothing was at stake and nothing changed does not mean this ruling is harmless, because it sets a precedent which other courts will likely cite in deciding BDSM-based cases.
It opens the gate for other schools or even municipalities to ban BDSM, or alternatively police it aggressively under existing sexual misconduct rules. It's unlikely that towns, cities, or states will start passing laws wholesale, but again, that doesn't mean there's no harm. It deals a blow to zoning clubs or BDSM events, the very things that make the community more open, friendly, and safe.
At the collegiate level, it may matter more. Colleges are much more proactive about policing sexual behavior among their students. We could see a lot of schools concluding that you can't consent to BDSM in order to protect vulnerable students. And we could see aggressive student councils rolling up BDSM into anti-coercion and campus sexual harassment policies. That in turn could hurt student organizations and create a more underground BDSM culture, which is patently less safe than one in which organizations can openly advocate for consent-based BDSM.
It could even hurt consent-based culture as conservatives, who oppose campus consent policies on principle, put BDSM into them as a poison pill to form a rift that pits sex-positive and sex-neutral progressives against each other.
So our analysis. The ruling is both unnecessary to the case and unnecessarily broad, but it makes a few things clear. Currently, BDSM is not permitted expression. It exists through tolerance alone, and practitioners have no expectation of protection of their rights.
The ruling matters because future judges can cite it as precedent when dealing with BDSM cases.
We feel this is a bad ruling. It invokes Lawrence peripherally, while reading around some of the very strong comparisons between BDSM and sodomy, as discussed in Lawrence. By refusing to acknowledge consensual adult sexual conduct as a basic liberty as outlined in Lawrence, Ellis doesn't feel the state needs to make a compelling case to restrict those liberties, merely just be protecting somebody in some way. We recall many arguments against sodomy focused on dangers, particularly in the post-HIV era.
Most thinkers and BDSM rights organizations have felt that it would be a few years before the nation and the Supreme Court was ready for a carefully groomed landmark case to set precedent on BDSM. Now they may need to move faster in the face of a really adversarial ruling.
We want to be clear. We don't advocate a world in which consent is not taken seriously and does not constitute the core of our understanding of permissible conduct. That said, this ruling is chilling in the current day and age.
Nor do we expect to see specific protections for choking your partner. What we do want to see is an acknowledgement that consensual adult intimacy falls within the bounds of traditional liberties. Protecting sexual expression does not and should not mean condoning non-consent or assault. For example, in regards to sports, State v. Shelley determined that consent is a defense to some assaults, but is limited to acts that are foreseeable and flow from the rules of the game.
What can we do? There's nothing you can do directly. It doesn't help to write your congressman. The decision is made and currently seems unlikely to be visited in appeal. It's out there.
The Doe case gives a good idea why rights organizations cherry-pick clean cases with sympathetic individuals to get positive rulings. John Doe is not a sympathetic figure, and nobody would willingly choose this case to set a precedent on BDSM. Curating a case in the court system is expensive and time-consuming, but it dramatically increases the chance of good results.
No rights organization has dared send a polyamory, sex work, or BDSM case forward with the current Supreme Court, because the court is heavily conservative. Nobody would have wanted this case to set a precedent. It has, and now it's likely organizations will consider putting better cases forward to challenge the precedent. It's going to take strategy and thought.
That said, what can you do?
First, and most importantly, support groups that work to establish the legality and legitimacy of BDSM. In the United States, we recommend the National Coalition for Sexual Freedom.
The NCSF is committed to creating a political, legal, and social environment in the U.S. that advances equal rights for consenting adults who engage in alternative sexual and relationship expressions.
The NCSF aims to advance the rights of and advocate for consenting adults in the BDSM, leather, fetish, swing, and polyamory communities.
Many of the arguments presented against BDSM hinge on the idea that there is neither a history of persecuting those who practice it, legally or socially, which is certainly untrue, and that BDSM itself has no strong history or tradition.
That's also fiction, and most of us know that. From Victorian flogging brothels to Venus and Furs to Betty Page, BDSM has been part of our culture for centuries.
We can recommend 2 organizations that work diligently to document the history of BDSM, fetish, and leather in the U.S. and abroad.
The Carter Johnson Leather Library is a non-profit 501c3 organization that consists of a traveling collection of thousands of books, magazines, posters, art, club and event pins, newspapers, event programs, and ephemera showing leather, fetish, and S&M erotic history.
The Leather Archives and Museum is dedicated to the compilation, preservation, and maintenance of leather, kink, and fetish lifestyles. The museum galleries serve to present educational and historical material to an adult audience. The reading library and archives serve to support researchers and community members in accessing materials and documentation relevant to the history and culture of leather.
Finally, just practice BDSM. Even where there are de facto laws against it, the non-enforcement of those laws has the potential to create, as in Lawrence, a tradition of non-enforcement.
In summary, a Virginia judge made a ruling rooted in the most conservative interpretations of constitutional law. Most of the ruling doesn't matter to us. What actually does matter is a side note, but because it went into an official judicial decision, it can now be cited as precedent by other courts.
The ruling wasn't necessary and represents a desire to make policy by setting a judicial precedent.
The ruling doesn't outlaw anything per se. What it does do is say that if towns, cities, counties, states, or universities want to outlaw BDSM, it may be within their rights to do so.
It isn't likely to have the police knocking at your door. It is likely to create friction and difficulties for those trying to organize safe spaces and open, consent-based BDSM communities.
Finally, to fight this ruling, practice BDSM, support NCSF or other organizations that fight legal battles to make practicing BDSM safe, and support the organizations that preserve and teach the history of BDSM.
For VMAP, I'm Rebecca Dahl.
And I'm James Gordon.
Remember, there's no right way to do Power Exchange.
Only your way.